Hancock Mutual Life Insurance versus Banerji.
Mr. Gilbert?
May it please the Court, Madam Chief Justice, my name is Robert Gilbert. I represent the appellant and the defendant below, Dr. Julian Banerji. This case is governed by a statute that was enacted in 1910, and the legislature did not operate on a clean slate at that point. It was cognizant, as Your Honor pointed out in the Apara decision, of decisions of this Court that had been made before. When the statute was enacted in 1910, Section 108 of the Insurance Code, it dealt specifically with disability and health and accident policies. And it had specific language that is not found in any of the other statutes that deal with other types of policies, such as life insurance or insurance statutes of general applicability, such as Section 186. The legislature made some deliberate decisions starting in the very first sentence of the statute, which states explicitly that that statute is defining policies as any policy or contract of disability insurance. That's an important point because then in Section 108, subsection 5, subsections A and C, it did two important things. The first thing that the legislature did in that statute was to specify that for any policy, in order to rely on a misstatement that was contained in an application, the application would have to be attached to the policy. And it provided two exceptions for reinstatements or for renewals. Again, the legislature was not operating on a tabula rasa. 5 years earlier in the Holden decision, this Court addressed the predecessor to Section 131 dealing with life insurance, which said flatly that you could not rely on a misstatement in an application unless the application had been attached to the policy. This Court held that that was not intended to apply to revivals of policies. And in response, in 1910, 5 years later, when the legislature drafted Section 108 dealing with disability policies, it said very specifically, number one, you cannot rely on a misstatement in an application unless it is attached to the policy. And number two, that this does not apply to reinstatements or renewals. In fact, it added an additional exception, the renewal, that was not contained in the original Holden decision. The legislature made a very specific decision in a very specific context that the only exceptions to the attachment rule would be renewals or revivals, reinstatements. What we are dealing with in this case is neither a renewal nor a reinstatement. It is a separate benefit, providing benefits, in fact, that are in excess of the original benefit provided when the original policy was issued. It is indisputably a separate contract of insurance. There is a separate application, which is determined by this Court to be an offer for insurance, an acceptance in the form of the endorsement issuing that provided a severable benefit that had, on the face of it, a separate premium that was paid. We had separate consideration, separate benefits. Hancock has made much in this case of the fact that the second contract, the FEP benefit, paying $1,550 in additional benefits per month, is dependent for many of its terms on the terms that are found in the original policy. And we agree. The FEP endorsement standing alone would make no sense unless it referred back to the original policy. But that does not change the fact that on its own, it is a separate contract of insurance, exactly as those words are used in Section 108, subsection 1.
I take it that the appeals court decision that the FEP addendum page was not a new and distinct policy is technically correct because the addendum page, as you said, can't stand alone. But what you essentially have is an amended contract, if you like.
Your Honor, I agree with everything you said except for the last few words. It is not an amended contract. It is a separate contract, severable as illustrated by the fact that the insurer in this case has brought an action to sever the FEP benefit. It was not an amended contract. In a sense, it was amended because additional benefits were added that weren't there originally. But it is, for purposes of the statute, a separate contract. And indeed, functionally,
Did it have a separate policy number?
It did not.
Well, doesn't that suggest that it should be viewed as part of one contract?
In one sense, it suggests it should be viewed as part of one contract. We do not dispute that you must refer to the originally issued contract, the policy, in order to make sense of the FEP benefit. But going back as far as 1854 in the Foster case, this court has recognized that even when subsequently issued contracts of insurance bear the original policy number, that does not render them one and the same contract.
No, of course. I mean, that is to say, if you focus on reinstatements, renewals, revivals, that. When I talked about an amended contract, I was not talking in the statutory language. You've got a new contract, as it were. I mean, it's not, you're not reinstating what existed. You've got different terms that are at issue.
Yes, that is correct, Your Honor. And the policy reasons behind the attachment requirement are every bit as vigorous with respect to the FEP endorsement as they were with respect to the original contract.
The misrepresentation that is asserted by Hancock here is a misrepresentation that does not apply to the original contract. Am I correct?
That is correct. It is a misrepresentation that was contained in the application for the FEP benefit, a separate application that was filled out 3 years after the original policy was issued. So our position is very straightforward. We ask only that the statute be applied exactly as it's written. This is not akin to a reinstatement or revival. It is separate insurance, deserving of the same protections that have always been accorded in the context of applications being required to be attached to the original policy. There's a second aspect of the statute that I would like to focus on very briefly, because, again, the legislature made a deliberate decision by using language that's found in no other comparable statute for other types of insurance. It used the word falsity, which in 1910, as it does today, has a very specific legal meaning, implying or requiring guilty knowledge. It's not enough to say something that's an innocent mistake. John Hancock, in the proceedings below, did not allege in the complaint, did not present evidence at trial, did not argue to the judge after trial, and did not request findings that there was guilty knowledge, scienter, that it was an intentional misrepresentation. Indeed, the evidence at trial was exactly to the contrary. And so applying Section 108(5)(c) exactly as it was written, using the word chosen by the legislature, which, as our authorities point out in the briefs, the terms falsity and false had very specific meanings in 1910 as today. Again, that would require judgment for the defendant, Julian Banerji, with respect to the core insurance claim. I would... Yes, Your Honor.
I was just going to, you can use your time whichever way you want to, but I would be interested in your question, in your addressing the attorney's fees question.
Yes, I would like to address that. The American rule is a judge-made rule, and it was created because it was the judgment of many courts, not just this one, but courts around the country, that it is a preferable way to handle the majority of cases. But as with any judge-made rule, it is subject always to judge-made exceptions, and there have been many through the years. I won't recount them all, but I would like to focus on the exceptions that have been identified by this court in Gamache and Rubenstein. In that case, there is a judgment that there are some types of insurance cases in which it is appropriate to have an exception to the rule that there is no fee shifting. We would argue that as the court is determining, and we are aware that in 1 hour you'll be considering this issue again, as the court is considering what types of insurance policies are deserving of an exception to the American rule, that there is probably no type of insurance that would be more deserving than disability coverage. The factors that were cited in the Rubenstein and Gamache cases are equally present in this case, and there is one additional factor which I would like to emphasize in this oral argument, and that is the question of access to justice. In the context of duty to defend cases, which were considered by this court previously, there was much attention paid to the idea of benefit of the bargain, and I would suggest that that is true in any type of insurance case. It would certainly be a plausible extension of Rubenstein and Gamache to say that the benefit of the bargain argument holds sway in all types of insurance.
And all types of contracts, in virtually everything. So where are we going to draw this line?
Well, you can draw a line because there are factors that are involved in insurance coverage in particular, but more specifically in disability coverage. Number one, it is a contract of adhesion, and I don't use that in a pejorative way, but it is a contract that is presented on these are the terms. And in rare cases, and that's one area where you can draw the line, if it's a negotiated contract,
Well, I mean,
that sets it
any
apart.
insurance is a contract of adhesion.
That's correct, Your Honor.
Well, then, what you're saying to Justice Cordy is, all insurance contracts, it's the losing party pays.
Standard form contracts. Many contracts are negotiated, specialized insurance. But moving to the area of disability insurance, disability insurance presents a unique category of policyholders. Number one, like most policyholders, not all, because some policies involve retrospectively rated premiums, but for disability policyholders, they have performed completely at the point when the disability occurs. It is only the insurer's performance that is executory. That's true in most types of insurance. Disability insurers are unique, however, in that they are specially situated where they have no realistic ability to vindicate their rights in court without fee shifting.
But as Justice Cordy suggested, that could be true of any contract where you have an individual against a large corporation, for example, a landlord-tenant.
Your Honor, I'm not speaking just of the disproportionate array of resources, although that's certainly a factor. What I'm speaking of is that a disability policyholder, by definition, has lost his health, lost his job, and therefore has lost his income. At the exact moment that he needs the insurance most, not only is he not being paid under the insurance policy, but if he has any hope of ever being paid under the insurance policy, he must go out and find a lawyer.
Well,
Never mind how he...
Certainly if the company is acting unfairly or engaged in some unfair practice, in sort of acting unreasonably, there may be other remedies that include attorney's fees. Here, first of all, you have to acknowledge that if accurate information had been provided on the application for the FEP benefit, he wouldn't have gotten it.
That is not correct, Your Honor, and actually there was no finding on that by the trial court. With respect to our counterclaims, where we had the burden of proof there was a finding, the trial court never entered findings with respect to the question whether John Hancock had met its burden of proof on the question of materiality. So there's not a factual record to support that. But there's a more important point I think that you're raising, which is, doesn't 93A provide an escape valve in situations where policyholders are faced with bad faith on the part of their insurance company?
176 are the insurance regulatory authorities, which are extensive. I mean, there are lots of ways to get at companies that act unfairly.
That's correct, and that was equally true with respect to Rubenstein and Gamache and the duty to defend. What I'm talking about is something that's core. It doesn't go to situations where there is unfair or deceptive conduct. It goes to virtually the entire class of disability policyholders. They have no money coming in to pay their mortgage, to pay health care premiums, to pay co-payments, to pay for child care. They have lost their job at the exact moment when all the promises that the insurance company made are needed the most. They not only are not getting the insurance coverage, but they are being told you will never get the insurance coverage unless you go out, pay for an attorney, and vindicate your rights in court. They don't have the ability to do that by definition.
Wouldn't that be true of every insurance policy? I mean, suppose it was for homeowners. You'd be arguing, well, the homeowner has lost his house and has to go out and hire an attorney and all that kind of thing.
That's correct. It's that you have to go out and hire an attorney. You have not lost your job and your income.
And we will consider that in about 1 hour, that precise question.
So, yeah, I'm cognizant, Your Honors, that there is line drawing that has to be made. Having opened the door in Rubenstein and Gamache, line drawing has to be made, and there has to be an inquiry. Do certain kinds of insurance involve a special relationship that we don't find in others? There are many factors, and I would suggest even that there's a matrix. Who the policyholder is, what type of coverage is being provided, what the circumstances are. We suggest that it's a modest step for disability insurance to go, to find that it falls into the camp of insurance coverage and insurance policyholders who do have a special relationship, and where the American rule, as more than one court has pointed out, simply operates very, very poorly.
Thank you, Mr. Gilbert.
Thank you.
Mr. Looney?
Good morning, Your Honor. Justices of the Court. My name is Edward Rooney. I represent the plaintiff appellees, John Hancock and Provident Life and Accident. I'd like to first to stick with the same issue that Mr. Gilbert just finished with the attorney's
On that
fees.
basis, let me just ask you, why should we distinguish this case from Gamache and Rubenstein as to fee shifting? Logically, what logical reason?
This is a first-party insurance case, Your Honor. Dr. Banerji paid a premium to buy disability insurance. There's nothing in that policy at all that talks about a duty to defend. The duty to defend is the key element in third-party insurance cases that distinguishes this policy from those policies. Gamache, Rubenstein, and Golden all involved third-party insurance cases where you have an insurance company, you have an insured, and you have two duties. You have a duty to defend and a duty to indemnify. In this case here, there's only one duty, to pay disability insurance benefits if they come due. The premium for third-party insurance is partly for the duty to defend, partly for the duty to indemnify. If you don't defend as you've contracted for and received the premium for, then you've breached that duty if you're found that you had an obligation to defend, and that's what you're paying for.
If you don't pay what's owed under the policy, the indemnity, you've paid a premium for that too, haven't you?
In the first-party case, if you haven't paid the premium, the premium goes solely to the duty to indemnify. It doesn't go to any duty to defend.
Yeah, but why logically is there a difference if you pay
sense.
for, in one case, for the duty to defend and to indemnify, in the other case you pay only for the duty to indemnify? Why is there a logical difference?
Well, the American rule so states it. The exception is because there's a promise to provide counsel.
It's
an attorney.
one step away from the attorney-client relationship, where you don't have that in these circumstances.
Right. There's no special relationship. You don't have an attorney-client relationship between the insurance company and the insured, as you do in third-party cases.
In truth, one of the answers is that we've carved out this exception.
Exactly. There's no attorney's fees provided, period. But because of the unique relationship and the actual attorney-client relationship that arises in third-party insurance cases where there's a duty to defend, provide counsel, and defend that insured, that's why the exception was found in the first place.
If we allow attorney's fees here, would you agree we'd have to allow it in every insurance case?
The exception swallows up the rule. Yeah, absolutely.
I mean, how could you justify a third exception for this case and not for any other case, whether it be homeowners or health insurance contract or automobile policy, any of those kinds of things?
Every first-party insurance case, life insurance, disability insurance, would all...
Have many states done this?
Well, Your Honor, I'll refer back to the Gamache case that you wrote. You relied on several cases from Maryland, from the state of Maryland. I think there's about 6 cases you relied on. And one of the cases you noted in a footnote is a case called Collier, where it was a case that was a special question from the U.S. District Court. And the question there was exactly the question that was raised here.
But isn't the answer to Justice Glaney's question that, in fact, other state Supreme Courts have adopted a general rule in insurance cases? I think Montana, Washington, a couple of other more recently.
I know Maryland hasn't. It's specifically rejected.
Maryland has.
Well, a few have and most haven't.
Yeah.
Exactly. And that would be true. Every first-party insurance case would have the obligation to pay the attorney's fees if the insurance company is found to be liable. And as Justice Cordy points out, there's already a remedy if an insurance company acts unfairly.
Except our language on that is you really have to show some either pattern or real
Deception,
unfairness. I mean, I don't think you want to be arguing on behalf of the insurance industry that you're better off loosening the requirements that we've had under
I think to make a further exception, in a situation where there's already protections afforded, I think is unnecessary.
In those few states that have adopted the exception to the American rule insofar as cases regarding the duty to defend, have they decided any cases on this issue? Have they decided any cases in which they were asked to extend the exception to other insurance cases?
That was the case I was referring to. In the Gamache case, Justice Graney cites to this Collier case, which was a Maryland state court case, and was asked by the U.S. District Court a specific question. And applying the rule that Gamache endorses, which is there's an exception, would that exception apply to a health insurance case where the insurer denied benefits, health insurance, as a same exact situation as we have here? The answer from the Maryland court was no. We would not apply it in that circumstance.
But again, that doesn't directly answer Justice Cowan's question, because the issue is not, the question wasn't what did Maryland decide, but have other cases, other states extended it to all insurance contracts, and the answer to that is yes.
Yeah, but I thought the question was more specifically to this
Okay.
this type of insurance.
What is wrong with extending it to all insurance policies if the insured has to sue and wins to get the benefits that the insurance company was supposed to give him or her in the first place? What is wrong with that? The insurers will just crank in some additional premiums to cover the cost, probably. We'll spread it out.
What's wrong with the American rule, Your Honor?
Well, the American rule is considered harsh in a lot of respects.
But it's precedent. It's the rule that all companies and all individuals have been operating under for 100 years.
And shouldn't decisions of that sort be made by the legislature, which highly regulates this industry?
Not
Certainly when it comes to insurance.
Not when we made the rule in the first place.
Yeah.
And
Well, the legislature has specifically provided in a number of statutes for the recovery of attorney's fees, recognizing that the American rule is the prevailing rule, has it not?
And it is a prevailing, I mean, throughout the United States. All 50 states follows the American rule. That's why it's the American rule. It may not be the rule in other countries, but it is the American rule, and that's what we've been operating under.
Well, maybe we need a Massachusetts rule.
We already have it in the third-party situation.
Well, certainly Gamache and Rubenstein, those are insurance contracts not provided by statute, and as I think will emerge, there are other states that have done this. There may be good reasons not to do it. There may be bad reasons not to do it. But it does strike me that at least one part of Mr. Gilbert's argument, which is and I'm not suggesting that this is the best place to draw the line, but what is a little different from disability policies, but may cover health policies, for example, is essentially what you're buying is your capacity to get paid an income. Your capacity to get paid an income includes being able to retain an attorney. If, in fact, you don't have any income, then your capacity to retain an attorney in order to make sure that you get the income that you thought you had been paying for over quite a long period of time is meaningless. A house burning down is a terrible loss to suffer. An automobile accident is a terrible loss to suffer, but in those situations, presumably, the policyholder is continuing to have whatever income the policyholder had in the past. And therefore, there is at least an assumption, if you don't have trust funds, that you will be able to litigate, if there's a denial of coverage.
Let me just respond to that, Your Honor, by noting the footnotes in the appeals court decision in this case. What Dr. Banerji didn't get here was the right to have overinsurance. The reason he didn't get this insurance, or why the action to rescind was brought, is because he didn't disclose group disability that he had at work. He already had the Hancock basic benefit.
No, I understand on the facts.
And so
he
when he went out on disability, he had the basic benefit of $18,000. He had his group disability of 60% of his income, which was another $34,000.
Right.
He had $52,000 of income.
So
in this case, it doesn't cry out for any correction of unfairness here, because he collected on, and he's still collecting on the Hancock policy. He collected on the group disability policy.
But he paid additional premiums.
What's that, Ron?
He paid additional premiums, didn't he?
And they've been refunded. The additional premiums for the additional coverage?
Yes.
He paid them,
Mr.
and then when it became known that he had all of this additional insurance, they were refunded to him.
Mr. Looney, I think it would be fair to say that one reason why the case is up here is because of the holding in the appeals court that didn't go to attorney's fees. Do you want to use some of your time to address the merits of whether or not the attachment should have occurred or not occurred?
Right. Very simply,
I mean, you don't have to, but if you want to.
well, very simply, I think the appeals court decision should obviously be affirmed because it followed very correctly and logically this court's decision from just 16 months ago in the O'Para versus Mass Mutual case.
That was a reinstatement, correct?
Correct, absolutely, Your Honor.
And this is not a reinstatement.
Exactly. But in fact, I think the reinstatement situation, it makes a stronger case for applying an attachment rule, but for the statute. As you noted in your decision, Your Honor, it was a newly issued policy. The original policy had lapsed. A new policy is issued, and it was changed. It changed from whole life to term insurance. It got redated to a new policy issue date. And this is not that situation at all. Here we have a policy. And in that policy, we have 4 benefits: a basic disability benefit, a rehabilitation benefit, a waiver of premiums benefit, and what we refer to as the FEP benefit. Those are 4 benefits in one policy. Dr. Banerji exercised his rights under one of those benefits, and he requested an increase in his benefits because his income had increased. He submitted an application, a request, whatever you want to call it, in accordance with the terms set forth in the policy. So the end result is what he got was simply an increase in his benefits as promised in the contract. So the statute itself, if you read it, it's 15 pages long, the statute. And what it does is it specifies, in essence, what a company can put into its policy, the terms that have to be in its policy. It's very extensive, and it's my position that these contracts are not contracts of adhesion. If they are, they're contracts of adhesions per statute, because everything that's in that contract has been put in there because the legislature told John Hancock that you have to have all this in the contract. So when you read Section 108, it clearly refers to the policy that was issued to Dr. Banerji in 1990. The document that's referred to as an addendum is really, if you look at it, what it's really titled is a schedule of benefits. It's a revised schedule of benefits. It grants Dr. Banerji a term addition. This is all language that's in the policy itself. He applied for and got a term addition. And the schedule of benefits page that came out, that one-page sheet of paper that came out, simply changes the schedule of benefits from originally saying term additions 0 to term additions $1,500. That's the only thing that's different. Same policy number, all of the basic boilerplate up at the top of that document, exactly the same as the original schedule of benefits. He's still got all the same benefits. It's just one policy, and he increased his benefits under that policy. It's done all the time.
But here, the claim would not be that the original application, that the whole thing had to be sent back again, but where you have an amendment to the terms, or whether you call it a revised schedule. I mean, it really is if I have a lease that requires me to pay $100 a month, and then I have, the same property, the same everything, but now it's $200 a month.
Same lease.
Well,
now
yes
you've got a higher rent.
Yes and no, but if the reason why we set it at $200 a month is because I misrepresented something about the $200, and that's not attached, it seems to me that you are, what Dr. Banerji is asking here is that at minimum, so much of the contract as is amended changed. You would not have had to pay him increased benefits, but for whatever the application was.
That's basic common law. I mean, if you make a misrepresentation in a contractual situation, turns out to be false, that's basic contract. That doesn't bring you into the statute.
But you only get the benefit of that, the statute says, if you attach whatever it is that the misrepresentation
But the statute says attach it to the policy. And again, as this Court held in Holden 100 years ago, these statutes apply only to the original policy that's issued. And that's been the law. And that's why Hancock didn't attach it to anything, whether you say it should have been attached to the policy or it should have been attached to the one-page sheet of paper. You didn't attach it because the statute doesn't say you're supposed to attach it. It's available, just like in the reinstatement application situation. If the insured calls up and asks for it or makes a written request for it, the company would provide it to them. Just like with the reinstatement application, you don't have to attach it in with health insurance, but if somebody makes a written request, the company's got to provide it to them in 15 days. And if they don't, then they can't rely upon it as a basis for rescission.
Thank you, Mr. Rooney.
Thank you, Your Honor.